Okay, so let's talk about some of the more common obstacles you may see in different cases. And can you give us an example of like some of the common obstacles that you see that buyers or sellers may come to you with?
Well, we get a lot of seller disclosure cases. So there's something called the Seller Disclosure Act. And what it effectively says is that a seller must tell a buyer about the condition of the home. There is no duty of the seller to inspect the home. So you don't have to inspect your own home. You don't have to hire a professional inspector. But you do have to disclose what you know. And you have to disclose within reference to the form itself. In other words, you only have to disclose what questions are asked on the form. Right. And they're important things like, are you aware of work being done without a permit? Are you aware of water infiltrating the foundation or basement? Is there a structural issue? So significant things that you would care about. And it's interesting to me, especially in our market now. The market is very difficult. It's a very strong seller's market, which everyone thought, including me, well, the bank rates are going up. Okay, the market's going to soften.
Anything.
In fact, I'd be curious what you have to say, but I'm hearing stories that the market, if anything, has gotten more competitive.
It has, especially in certain areas. So the more desirable the area is, it's like people are still bidding way over asking price. When I say like I have a client that's looking at like Dearborn, Allen Park, like those houses are easily selling over. If it's updated, of course, they're easily selling over like $20,000, up to the highest one I've seen so far in this current market is $40,000 over asking price. So it's insane. I can only imagine like in Oakland County and Macomb County how people have money, feasible money, where they can just go over asking price and they can waive like the inspections, appraisal, and things like that because they have the excess capital. So it's like, yeah, it's crazy.
I spoke to a woman this morning and she has looked at 40 homes. She'd made 6 offers that were either at asking or she said as much as $5,000 over asking. She has not even gotten a call back.
Oh, that's because you need an agent like me. Because there are strategies you can set in place. Like sometimes what you can do is instead of looking for properties that are just going live on the market or coming soon, maybe take a look at properties that have been on the market for days, right? So days on the market is really important, right? Because the newer houses, they tend to have more buyers, so more competition. So if it's a house that's been sitting on the market for like 7 days, take a look at it and just be open-minded to like the cosmetic things, as long as you don't have any structural issues or the roof isn't bad. And if you just have to do like a updated kitchen, a bathroom, see those options because honestly, it'll save you a lot of time and money.
So that's what's going to be my point is what I'm seeing is because people are so, I guess, desperate, maybe is the right word, to get into the marketplace or to get to a bigger home or to downsize or wherever they're trying to get in the real estate market, people are waiving inspections, which is very dangerous. I'm not saying it. I'm not going to say you shouldn't do it, but it's very dangerous. But they're also, to me, looking past other issues. Right. And, to me, a buyer needs to sort of temper, I want to be in a home with, I don't want to be in a home that's not going to be what I thought I was buying, that I'm going to be buying, a property that needs $25,000, $50,000, $75,000 worth of work that I didn't plan on. If you plan on it, that's one thing. Right. Say, well, hey, I'm going to put this much money in, the price is right, the total I'll have into it makes sense.
But you don't buy at the top of the market and still have to put that much money into it.
And we see many situations where, I'll give a recent example. Okay. Person bought a home, and they called me up and they said, Rick, I bought the home, I moved in. Within 2 weeks, I found water in the basement. And the seller never told me about water in the basement.
Was it on the seller disclosures?
Well, I'm going to get to that. That's the exact question you had. So I said, so they never disclosed it. No, Rick, they never disclosed it. And I said, okay, well, if they've never disclosed it, that puts you in a pretty strong position to file a lawsuit for a claim of fraud. And they said, send me over the seller disclosure, send me over the purchase agreement. So they sent it over, and I look at the seller disclosure, and I said, well, it says, has there ever been evidence of water in the basement? They wrote the word some. And I said, I'll just use Mrs. Jones. Mrs. Jones, when we talked, I asked if there had been water in the basement, and you said they no disclosure, but it says the word some.
Right.
Well, Rick, that's true. It does say the word some, but let me tell you what happened. I spoke to the seller. I went by the house and was showing someone in my family and saw the person there, and I said, hey, what does some mean? And they said, oh, well, it was some was just in the corner, the northwest corner of the basement, and I'd only seen it a couple times, and I don't really know why, but it was just some. So. And that was the end of what was said. They buy the house. And the problem is that, and I'm not saying this is what the seller did, but if some seller said, Rick, look, I'm going to commit fraud. I'm going to lie to my buyer. What's the best way to lie to my buyer?
But being as vague as possible.
Well, being vague and under disclosing. In other words, don't say never been water.
Right.
Use the word like some, because some doesn't mean anything. It doesn't have a legal definition. It doesn't tell me if there's 3 inches across the whole basement, or it's like a damp spot that's as big as a basketball in the corner. It doesn't tell me anything. It just says some. And unfortunately, what I had to tell the client is, look, you can hire me, but you don't want to hire me because these cases are expensive. And to prove fraud, which is what you're asserting in these kind of cases, you have to prove that the seller lied to you. And in this case, they said some, and they said, yeah, but Rick, they explained to me. And I said, yeah, but none of that's in writing. All you can tell me is the words. And I'm going to guess somebody that committed fraud the first time is going to commit fraud the second time in court. And they're going to say, oh, I don't remember that conversation. No, I wrote some because there was some water there. And so this person didn't hire us, which I tell people, I'm like, I want to be hired, but I want to be hired because I think we can do something.
Right.
And the client is fully informed as to what we think can or can't happen. And so kind of going back to your question, some of the things that I think buyers do is they get either too eager or too trusting. And I'm not one of those people that thinks everybody's lying. I don't think that. I think most people tell the truth. But when you're going to spend the kind of money that you're talking about to buy a house, you want to be as certain as you can. Get the extra inspection. If someone says get a sewer inspection, get the sewer inspection. If someone says get a pest inspection, get the pest inspection. Make sure you've done everything reasonable to investigate the property before you spend whatever it is. It's going to be something significant.
So you can never be too safe.
Correct. And people say, yeah, but Rick, well, what if I find out something and I don't buy it? And I'd say, it was still worth it because you found out something that you avoided a problem. So if you spent $1,000 on inspections, I'd say money well spent. They say, but Rick, if they don't find anything, then I just wasted my money. I'd say, no, then you have the peace of mind of knowing that the house is in good condition. So
I would never tell my clients to waive an inspection. If anything, if it's so competitive, but they really like the house, we have an hour, 45 minutes, an hour to tour the house. So you need to call your inspector and have them there as we tour the house. So at least they can take the time to look at the house to make sure you're buying a house that's going to give you your return on your investment. Because ultimately it's investment, right? It
is. And I agree with that. I understand their competitive markets. I've had clients that waived inspections. When I say clients, I don't list real estate. But as a lawyer, I've had clients say, Rick, I want the house. What should I do? And I say, well, I'm taking a big risk. I'm going to take the risk, Rick. So how do I minimize it? And your suggestion of bringing an inspector, going through and looking at the house, you want to make sure, in my opinion, you really want to make sure that you've investigated the house to the best of your abilities. Now, on the flip side, say, well, Rick, okay, you're talking to buyers, but what about sellers? Of course, as a seller, I don't want an inspection. I actually have a little bit different opinion. And the reason is because if I'm a seller and I sell the home and there's no inspection, I would be worried that if a buyer finds something, and that doesn't mean that the seller lied. The sellers don't always know. There is a first time that water goes in the basement. There's a first time that a roof leaks. They're always the first time, and it could be, during that transition. But what I'm worried about as a seller is the buyer says, I'll waive the inspection. Well, first of all, I'm worried that during that sort of due diligence period before the closing, that the buyer might get cold feet and say, wait a minute, I'm spending $300,000. I never even had it inspected. And what if and my dad said, be careful of this. And my brother said this, and my sister, and I don't want to do this anymore. And they walk from the transaction because they're scared. So that's one reason. But I think the bigger concern I have is that we were just talking about, well, if you're a buyer and there's some water in the basement, even though you might not know exactly how much water is, it makes a fraud case harder. You've got to do some investigation to really find out. And the court looks at you and says, well, you had a clue. It said some. And so it makes it much harder to prevail in court. Well, Now I'm the seller, and my buyer didn't get inspection. They waived it. So the only thing they're relying on is what that seller disclosure says. And I would be worried that in court, a judge might say, well, wait a minute, seller, you knew every single word in here was going to be relied upon by the buyer because the buyer waived their inspection. So any words in there that were unclear, well, court might look at it more favorably for a buyer.
Wow.
Now, I'm not saying I've seen that happen, but it just makes me a little nervous that a court might say, no, seller, you knew exactly what was happening. You had a duty to make sure that you were clear and articulate in your words. And if you didn't do a good job of explaining, where you answered yes, say to any question, it could possibly work against a seller in court.
So the inspection can protect the seller if they have that accurate
I think so.
Documentation.
Well, so here's an example. I can think of other cases where someone said, well, Rick, there was water infiltration and there was water damage on the wall and there was just some rot in the wood. And they never told me anything about that, Rick. And they sent her the seller disclosure. Doesn't say anything about that. So, okay, so you had no idea. Nope, I never had a clue. I said, okay, now you get an inspection. I did. Send me over the inspection report. In the inspection report, the inspector writes, evidence of prior water infiltration, would have a contractor look at the cost of replacing the wood. And the buyer says, well, but Rick, the seller didn't tell me that, and they have a duty to tell me that. And I said, the standard is if you know, I don't care how you know, if you know as a buyer, then you cannot claim fraud. And so if there's an inspection, from a seller standpoint, you had a second set of eyes, which either A, they may have found something, and now the buyer knows, or B, they didn't find something, which I would say as a seller, that's right, I didn't know, and they didn't know. So if there was something, maybe it just happened, or maybe nobody would have found out. And sort of on that same point, I can think of one in St. Clair Shores. Person goes to the house for the 48-hour walkthrough. So right before they're about to close, they want to just make sure the home's in the same condition.
It's the final walkthrough, so it's typically done 48 hours before closing.
Just to make sure the home is in the same condition it was when you signed the purchase agreement, did the original inspection, just like it was, but for a little wear and tear. And the person sees water in the garage. In fact, there's the owner is with two adult kids, and they're literally bucketing water out of the garage. It was a detached garage, but it was very close to the house, and they're bucketing water out. And the buyer says, but wait a minute, you never disclosed that. I mean, there's like 4 or 5 inches of water in there.
But at that point, they can walk away, right?
They could walk away. But instead, they purchased, and then they wanted to sue. What? It's not that unusual.
They knew of it, though.
I know.
How did you proceed with the transaction?
So they pursued, they consummated the sale. And then they said, Rick, we've got to go after him. There's, the water in the garage. I mean, I never knew about it. And I said, yeah, but in your story, they told you before you bought. Well, what was I supposed to do, Rick? I didn't have anywhere to live. And I'm not making light of that. I understand. And what the court would say is, if you buy, you've accepted it. If you don't buy, which you don't have to, maybe you have to get a hotel. Maybe you have to sleep on a friend's couch. Uncomfortable things, but
that leads into my next question.
Not as uncomfortable, though, as buying a house when you know there's damage.
Exactly. So what happens when this is perfect. So what happens when someone have breached a contract? It could be a buyer or a seller. Can you give us some examples, like how would that play out in court?
Sure. So the most common breach we see with a seller is they refuse to sell. They change their mind because maybe somebody offered them more money or whispered in their ear, hey, I'll pay you more, $5,000 more than Cheri will pay. And so they decide to be uncooperative with the buyer, or they just say, yeah, we changed our mind. And a buyer in that position it's a tough position because a buyer says, well, but I want the home. And okay, well, then I go to an attorney. And an attorney will tell them you can get what's called specific performance. Most of the time when there's a breach of a contract, the parties go to court and the party that says, hey, the other party breached, I was damaged. Damages usually equals money. So pay me a certain amount of money. But in real estate, specifically if you're the buyer, there isn't, let me take a step back. The courts look at every piece of property as unique and distinct. So even though we might have the same exact bungalow in Oak Park and it looks identical, it's the same floor plan, it's the same everything, courts view that as different. They're not the same. They're very close, but they're not the same. And because the courts view them as unique and distinct, the courts say, look, if you don't get to buy the bungalow at 123 Maple Street, there isn't an amount of money we can give you to make you whole. We don't know what we don't know. I mean, you didn't pay for the house.
Can they like show that they missed out on other opportunities because of they're in contract with that house? Or
you could try to show that, but generally that's not going to succeed. But what the courts say is, because it's unique and distinct, we couldn't say this many dollars would be fair to you, buyer, if the seller breached. What the courts do say is, we will make the seller sell to you.
Oh, wow.
And we have done it many, many times.
So how long do you have to be within contract for the judge to give that ruling?
So if we sign a contract today and tomorrow the seller says, I'm not selling, you can go to court the next day. Now, realistically, it won't be quite that fast, but you could, by law, you could go to court the next day and sue and say to the court, force the sale. And courts will do it.
Wow.
They 100% will force the seller to sell. And I'll come back to specific performance in a second, but let's talk about from the sell side. So people often say, okay, Rick, so you're telling me a court will make a seller sell. If the seller breaches, the court says, if you've breached seller, you have to sell to the buyer if the buyer wants it to happen. I say, yes. Okay, Rick, well then the same must be true. If the buyer breaches, the seller can make them buy. And the courts say, no. And here's the reason, which we kind of touched on earlier, and that is that if you're a seller, what do you expect from a transaction? You expect money.
Right.
And so the court says, we're not going to make that buyer buy. But buyer number one, they default. They say, I'm not buying. And they don't have an excuse. They don't have a finance contingency or an inspection or title, anything. They just say, I don't want to buy. The seller then finds, or their agent actually finds, buyer number two. And let's say buyer number two is paying $10,000 less than buyer number one. The seller sells to buyer number two. They get $10,000 less. They can now sue buyer number one for the $10,000.
The difference.
And generally speaking, they will win. And the idea is that the seller is made whole between the $10,000 from buyer number one and the rest of the price from buyer number two. They're whole. They got everything they were entitled to. And that's why the courts don't make buyers buy.
And they keep the earnest money deposit too, right?
They keep the earnest money deposit, yes. Now, as a practical matter, if, going back to the buyer and the seller who won't sell.
Okay.
If you're a buyer in that situation, you want an attorney to send a demand letter that says, look, you've breached the contract. I demand that in writing, seller, you acknowledge that the contract is valid, binding, and enforceable, that the buyer is not in breach of the contract, and that you will consummate the sale pursuant to the terms of the contract. In other words, just perform. In addition, you want to have the attorney file a claim of interest. And a claim of interest is a document that kind of acts like a lien. And what it does is it prevents the seller from selling to anyone else.
That's typically when a contract is sent through title, right? To title, that's when that interest is set in place?
Well, when the claim of interest is filed with the Register of Deeds, that once it's in place, the seller can no longer sell the property as a general rule. Because if that claim of interest exists, the new buyer can't use can't get a warranty deed, can't get title insurance, can't get a loan. So it effectively blocks all new buyers. And if a buyer said, I don't care about all those things, I'm a cash buyer, and I'll take a quit claim deed. When you take a quit claim deed, you are effectively stepping into the shoes of the seller. So that claim of interest that says, hey, I'm buyer number one, and I have this contract, and seller refuses to sell to me. If the seller sold to some other seller with a quit claim deed, buyer number one just goes to that seller and says, now you must sell to me, or I'll sue you.
Oh, wow.
So when you file that claim of interest, it's like handcuffs for a seller. Now, it shouldn't be done unless it's appropriate.
I never knew that.
But it acts like handcuffs, if you will. A seller cannot sell to anyone. Everything now passes through the buyer.
Do you see that often? Like cases like that often?
Well, we see it often, but I think that's part of because of what we do.
Right.
We see it once a week.
Oh, wow.
But I don't know if it's that common.
Yeah, I never experienced anything.
But yes, it's sellers, all kinds of reasons. They don't want to sell. They change their mind. We've had people who say, I don't want to sell anymore. I can't find a new home. That's a classic one that we see in the last.
There's a lot of contingencies, and a lot of times just so the person can sell the house, they don't disclose that. So whose fault is that? Is that like the agent fault or the seller fault?
Well, the the contract control. So if a seller says, I'm only willing to sell if I can sell my home, if it's not in the contract, it doesn't matter that that's what the seller was thinking. It's what does the contract say controls. Now, in my mind, I wouldn't blame the listing agent, but if I'm the listing agent and my seller keeps saying, well, I'm not going to sell unless I have a new home, I would make sure they understand, look, if we put a clause in this contract that says the seller can terminate if they can't find a new home, no buyer is going to accept those terms. And so, seller, you have to sort of make the leap of faith. If you want to sell, you're not going to be able to have those terms there. No one's going to agree to that. So either A, maybe you shouldn't sell, or maybe we should find a new home first, and then you buy it, and then we sell, or just accept that once you sign that contract with the buyer, you have no ability to terminate. The buyer has the ability to terminate, but generally speaking, the seller has no ability to terminate.
Yeah, that makes a lot of sense.
One of the other things, and you have to move me along if you have other questions, but
I have one more. This is a big one. I learned this when I was in continuing education with you. But I wanted to take a second. If you are still watching this video and you are enjoying this conversation, make sure you hit like, subscribe, and the notification bell, because honestly, this is so much value, right? We had a great conversation. I kind of don't want it to end because I'm learning from you right now. It's insane. But let's talk about foreclosures, right? A lot of people don't know that before going to foreclosure, you can correct me if I'm wrong, you can get your equity back.
So if you're talking about a mortgage foreclosure, so in a mortgage foreclosure, what happens is there's a whole legal process, but effectively the house is sold at an auction. And at the auction, it's open to the public. Anyone can appear and make a bid. The bank or lender will make an opening bid by law. Typically, that amount they bid is the amount of the mortgage. So you owe $100,000, they make an opening bid of $100,000. Then anyone else who attends can make a bid higher. So let's say there's equity in the home. So you owe 100, the bank bids 100. And then 3 or 4 people keep bidding against each other, and now it's 130,000. Well, the bank gets the first 100,000. That's what they're owed.
Right.
The home, after the redemption period, so there is 6 months in which the homeowner can get the property back, but assuming they don't get it back, either they don't want to or they can't afford it, they don't get it back.
In that redemption period, would you advise someone to sell before it goes to foreclosure? Or
well, if there's equity in the home, yes,
right, absolutely.
And a lot of times, especially in this market, there's equity because if you don't sell, so we'll use our example. So owe 100, it gets bid to 130. Homeowner says, I don't want to redeem it, or I can't afford to redeem it. The homeowner, after the 6-month redemption period, they would be entitled to go after that $30,000, that equity. And there's a process. You have to go to court, but it's actually pretty painless. It's we help people if they want it, and it's under $1,000. It's worth doing. But the reality is, using the same example, banks owed 100. High bidder at the sheriff's sale bids 130. Well, somebody from the public bids 130, and we represent these people. They're smart, shrewd investors. If they're willing to pay 130, that means if you listed the property, it's probably worth 160 or more.
Way more.
Because they're investors. They're not buying it to live in it, so they need a bigger discount for them to make money when they resell it to the general public.
They typically use the 70% rule, right?
That's what we see. We see that generally they will not pay more than 70% of what they think it's worth in its current condition.
Right.
And they're conservative. They're careful. They should be. And so a lot of times they'll find a home that's in pretty good condition or really good condition. And so there's an even bigger amount of equity in the home when they get it. And so if anybody has a property that goes to foreclosure, and first of all, I go to my real estate professional and say, is there equity? But let's say you're maybe not in a good emotional place, you're sad about what's going on, I'm sure there's other things happening.
Of course.
At the very least, find out what it went to sale for, because if it went to sale for more than what the bank bid, there's equity. There's either money to get, or to me, to get the most money out of it, you want to have a real estate professional like Cheri list. Really, that's, bad things unfortunately happen, and emotionally it can be very difficult.
Yes.
The worst thing you can do is keep your head in the sand and not react. And even just a call to a real estate professional, they'll know what to do. They'll guide you through. They'll help you get that equity out so that at least for the next place you go, maybe it's a softer landing, maybe it's the ability to squirrel some money away.
Is there a time frame in which
There's only 6 months from the time the sheriff's sale occurs to when the redemption.
After to get the equity if they sell.
So the equity is held by the county treasurer, or actually the sheriff's department at the county, for 3 years. After 3 years, it escheats to the state, which is just the term. It goes to the state automatically. It's an unclaimed fund, like a unclaimed lottery, or I don't know, any kind of funds that someone's holding that's not theirs. Unless someone makes a claim on it within 3 years, by law, it must go to the state.
Wait, can anyone make a claim on it?
Well, anyone that has a valid claim.
Okay.
No. You can't just become like, hey, I'll claim that. No, you have to have a valid. That's funny. You have to have a valid claim. But if someone with a valid claim doesn't step forward, then that money goes to the state. A lot of money goes to the state.
And it's just a simple form that you have to fill out, right?
It's a pretty straightforward form. You have to actually file a lawsuit, but it's really.
It's easy.
I mean, it's very straightforward.
Listen, it's worth it, right?
Yeah. Oh, yeah. Even for anything $1,000 or more, you want to go after it. It's worth it, absolutely. But again, if there is $1,000 or more, that means you really want to call your real estate professional, because there's even more money available in a sale.
Yes.
Absolutely.